Oh, this is great. It's so wonderful to be here. The title of my talk is Tailored Suits, and one might think it's going to be about David's wardrobe, but it's not. This is about civil litigation. And I'm going to be starting off small, talking about a couple of examples, and then hopefully thinking bigger about this project. So here's an example. Several years ago, two young women, 20 years old, were on their way to a non-alcoholic dance club, and they got lost in New Jersey while driving there. They got angry at each other. Allegedly, some blows were exchanged, and unfortunately, one of the young women ended up halfway outside the car, being dragged down the street, and she suffered some injuries. None of them were, well, she had a broken nose, lacerations, a herniated disc. The victim brought suit against the driver of the car. The driver alleged that she'd been acting in self-defense. Before trial, the two women entered into an unusual contract. Under this contract, if the driver was less than 50% at fault, then the victim would recover $6,000. If it was exactly 50% fault, the victim would get $11,250, and more than 50%, the victim would recover $22,500. Here's a graph showing the contract that they had written. Along that horizontal axis is the percentage of fault of the driver. Okay, so it's two plateaus. Now, interestingly, this is very different from what would have happened in the absence of a contract. New Jersey is a modified comparative fault state. So this is what New Jersey law would have done. Below 50% fault, the victim would have gotten nothing at all. And above 50%, the damages would have been assessed in proportion to the driver and the victim's fault levels. So these two women had contracted around the law. This happens in a variety of different contexts. And we can talk more about that later. I want to give you another example about contracting around the law. This is an example of a high-low agreement. High-low agreements are actually relatively common in civil litigation. So several years ago, here in Massachusetts, a tragic situation, a baby was born, very sick and suffered injuries while in the hospital. A jury awarded the family $24.4 million, but the actual payment was only $5.3 million. That's because the family and the defendants in this case had written a high-low agreement before trial. A high-low agreement will cap the damages at a high level, in this case $5.3 million, but also establish a floor. So under this contract, the plaintiff, in this case the family of the baby, would be guaranteed a minimum amount, but the liability would also be capped at a maximum to pull in any runaway jury award. And this was binding, so the family only got that $5.3 million. Here's a picture of the high-low agreement. Without that high-low agreement, the family would have gotten the full amount, that $24.4 million. Now, examples like these two that I showed you, I find fascinating. I find them fascinating for several reasons. First, it makes me wonder if the families, if the plaintiffs and the defendants can write contracts like this, why can't they get all the way to an out-of-court settlement and avoid the risk and the costs of trial, altogether? How can they get this far and not get all the way? And then secondly, are these kinds of contracts, are these contracts in the interest of society more broadly? Is the world a better place if we allow parties to write these kinds of contracts? Or should we somehow regulate them or limit them? So in my work, in several papers, I've both studied these in theory as well as in data sets. I'm going to be telling, I know I have very little time, so I'm going to tell you a bit about the theory. The theory of settlement. There's a long history of the economics of settlement. The theory typically views settlement as either settle or go to trial. You either settle out of court for a flat amount or you go to trial. But examples like the ones I've shown you illustrate that there are all sorts of other possibilities that are available to plaintiffs and defendants. There's a whole array of things that they can contract on. They can tailor their lawsuits to suit their own tolerances for risk and their own beliefs. So let me tell you a little bit about the theory. I'm going to show you a little bit of algebra, but it's going to be over in a couple of slides. Hopefully it'll be gone in a flash. Okay? So the idea behind the theory is that the two parties, the plaintiff and defendant, are arguing before a trial. The trial is uncertain. There's going to be some randomness at trial. And so just to keep in the back of our minds, here's a bell-shaped distribution illustrating the possibilities of what could happen at trial. Now, I've drawn it as a bell shape. It could be either win or lose, in which case the distribution would have two spikes in it. But I'm just doing a nice bell-shaped curve here with an average, that mu naught, that Greek letter. Now, parties have an incentive to settle out of court rather than go to trial because trials are both costly, you have to pay the lawyers, as well as risky. And if the plaintiff and defendant are risk-averse, they're going to want to settle to avoid the risks of trial. So if the plaintiff and defendant have the same beliefs, if their beliefs are aligned with each other, then there's a settlement range. There's a range of values for which both the plaintiff and the defendant are better off settling out of court for a flat amount rather than going to trial. That's what I've shown you in the picture there, the bargaining range. Okay, so why do some cases go to trial? Why don't all cases settle out of court? Well, if the plaintiff and defendant have divergent beliefs, and if the plaintiff is more optimistic about what will happen at court than the defendant is, so here in my picture, the plaintiff believes that the damage award is going to be higher than the defendant. In these kinds of situations, that settlement range can disappear. There may be no settlement amount that both the plaintiff and the defendant would prefer to going to trial. So that's the basic theory, the economic theory of settlement, that parties will generally settle, but if they have very divergent beliefs, well, then they're going to go to trial. What I've done in my work is I've allowed the parties to contract on the outcome at trial. Suppose they have other options. Imagine they can write high-low agreements, or that agreement that was written by those two young women with the car incident in New Jersey. Suppose they could write contracts. What would they do? Well, what they would do is they would write a contract that may provide them with some insurance against the risk of trial, but at the same time tying their contract and the payments to the future outcome at trial. Okay, let me give you an example. With nice bell-shaped distributions, like the ones I showed you before, what one can get popping out of this apparatus is that the contract may look something like this. So the plaintiff and defendant may agree that the defendant will pay a flat amount of money to the plaintiff, plus a percentage of whatever the court says that the damage award is. So in my picture, there's a flat amount that's being paid, $50,000 plus half of the damage award. This is a contract that has a slope of 1/2. So rather than going into a naked trial where the court will just award X, the parties agree ahead of time that it'll be 1/2 of X plus a flat amount. Okay, so now I want to think a little bigger about what's going on here. Okay, this is what popped out of the theory. What is going on here? Well, through contracts like this and through high-low agreements, they're able to reduce the risk of trial. The plaintiff and the defendant benefit from the lower amount of risk. Now, tying it into financial services, what's going on here is that the plaintiff is playing the role of an insurance company. It's as if the defendant is paying an insurance premium K and then receiving a 50% reduction in its risk exposure. Let me pause for a moment. With full out-of-court settlement, when a plaintiff and defendant settle before trial, the defendant is getting full insurance. They're paying a full amount to the plaintiff in exchange for no risk at all. What my work is showing is that there are intermediate situations where the defendant can essentially get 50% insurance or any percentage insurance. The world is open to them. In addition, one can think about the defendant as playing the role of a litigation funder. So the defendant is paying a flat amount of money, K, in exchange for a 50% equity stake in the plaintiff's claim. Okay? Now, through these contracts, through high-low agreements and through these kinds of equity deals that I'm showing you, the plaintiff and the defendant can themselves achieve the benefits of these financial services without going to the external capital market. And indeed, the plaintiff and defendant, as parties to the suit, probably have more information about their case than outside insurers or outside litigation funders would have. So I think I haven't even been keeping track of am I totally out of time here? Okay. So the conclusion, my last slide, prior theoretical work on litigation and settlement has thought about the world as an either-or. You either settle or go to trial. That's too simple. Litigants can and do write contracts with each other that are made contingent or conditional upon the outcome at trial. They do it to suit their own beliefs and their appetites for risk, and these contracts are enforceable. You know, and indeed, I should kind of pop in here that in New York, there's a summary jury trial program where the judges who are participating encourage the litigants to enter into high-low agreements. My co-author, J.J. Prescott, and I have data on 3,000 cases that went into the summary jury trial program, and 80% of those cases had high-low agreements in place. Moreover, in big data sets that I've studied in the insurance industry, as well, many, many high-low agreements are being written. So thinking big, the contracts are allowing the litigants to perform the roles that are usually performed by outside investors, including funders and insurance companies. Should these contracts be legal? Well, why not? You know, why not? The parties write them because the parties want to, and so perhaps we should just let them do what they're going to do. On the other hand, through these agreements, they may be stimulating more litigation. More cases may be going to trial as a consequence, putting more burdens not just on the parties themselves in terms of the cost, but also on us as taxpayers. Okay, so I think that's where I'm going to end.